Good afternoon, everyone. My name is Madhusudan, and I welcome you to this next lecture of N100 series in which we are discussing the complete polity from mains perspective. Now, we are in the last leg of our uh, series. There are two lectures left. In today's lecture, I am going to discuss you non-constitutional bodies, and in tomorrow's lecture, we are going to discuss the comparison of Indian constitutional scheme with the other constitutional scheme. Good afternoon, Manoj. I hope you have enjoyed the Diwali very safely and with a lot of enthusiasm. So let's maintain the enthusiasm that we had started our classes with. And as per in syllabus, the wording that has been used is statutory bodies, quasi-judicial bodies, regulatory bodies. So we are going to see what are those regulatory bodies, what is this NHRC, and we are also going to see the consumer protection in India. So these are the themes that I have selected, and also like I had given you for constitutional bodies, that see there are certain common problems. Similarly, with respect to regulatory bodies, also there are common problems that are there with all the regulators. Only thing is that if in the context of some particular regulatory question is asked, you have to give one or two examples for those regulator. Less the problem solution, everything is same for all the regulators. Okay, so let's start the today's class by. But before moving further, one thing that is left that we had studied in last class about the National Commission for scheduled caste, scheduled tribe, backward classes. One aspect like National Commission for Women has been asked to UPSC. So I expect that next time turn is for minorities commission, and anyway minorities are always in the news. So that's why today we are going to discuss along with the other topics that I have mentioned the minorities as well. And for minorities in our constitution there is a body, or rather there is just one officer, a special officer for linguistic minorities. See, in original constitution, like in case of National Commission for Scheduled Caste and Scheduled Tribe also, we had mentioning of a special officer only. Later on they were converted to National Commission. But for linguistic minorities the word a special officer is there. So this is as such we are studying it in non-constitutional bodies, but as such this is a constitutional body. Can you tell me the article number? The article number that establishes this national commission, sorry, a special officer for linguistic minorities. Yes, you are right. It is article 350B. This is the article that establishes a special officer for linguistics, and this is relatively short article as compared to the articles on National Commission for Scheduled Caste, Scheduled Tribe, because it has limited number of provisions. Like it has provision for investigating the safeguards provided to linguistic minorities. Okay. Second is, obviously it will, after investigating, what will it do? It will report to the president, and what will president do? President will cause the report to be laid before the parliament. What is missing here? You must pay attention that one thing which is missing is they do not do the grievance redressal for individual complaints. Okay, that is not in their mandate. And second, the development work. So what is not there is grievance redressal. What is not there is development, socio-economic development, which was the mandate of other national commissions. Their mandate is limited to investigate the safeguard. Okay, and here also like minorities, it is mentioning only about linguistic minorities. Minorities are there on two grounds. One is linguistic minorities, other is religious minorities. Their mandate do not extend to religious minorities. Is it clear? If you have any doubt, please ask me, because see, if a question comes, only aspect that you have to deal with that what is not written for them. This is how you will distinguish your answer as a well-read answer. And in my opinion, the question is not going to be on a special officer for linguistic minorities. Rather, the question is going to be on minorities. And minorities were also in news because of this Supreme Court judgment. The Supreme Court has said that minority status of religious linguistic communities is a state dependent. Okay, so if a community has less population in a particular state, that community would be considered linguistic minority in that state or religious minority in that state. Okay. Second point that you need to understand is that even OBC status was declared a state specific. Okay. But in case of OBC, there is a central list and there is a state list. This judgment does not make it clear whether the similar arrangement has to be made. Okay. However, like the very fact that there is a declaration of minorities at the national level and the Supreme Court has said that a specific minorities, religious and linguistic minorities is state dependent, implicitly it means that probably both central government and state government can maintain their separate list of minorities the way they maintain their separate list of OBCs. But like in case of OBCs, the constitution has explicit provision that this is going to be the list and central list and a state list can be different. The constitution does not have any specific provision with respect to minorities. Okay, whatever information that we have is from Supreme Court judgment. And apart from that, there is a National Commission for Minorities Act 1992. National Commission for Minorities Act 1992. This act also declares how many minorities are there in India? Please answer. Religious minority I am asking. There are as of now 6 communities which are recognized as minorities in India. They are Muslim, Christian, Sikh, Jain, Buddhist and Zoroastrian. Okay. That is also known as Parsi, Zoroastrians or Parsi. So these are the 6 communities that are known as minority. Yes. You are right, Manoj. So they are declared by this National Commission for Minorities Act 1992. Now, in this judgment, Supreme Court has also told one more thing. The Supreme Court has said that religious or linguistic community which is a minority in a particular state can claim protection and right to run own education institution under Article 29 and 30. Even though, listen to me carefully, even though the state has not declared them as minorities. So, actually, there are a few states like 9 of the state and union territories where Hindus are in minorities. You may like to note it down as well. There are 9 states and union territories combined where Hindus are in minorities. So, like the case was there in Supreme Court. First, you may note it down. Which are those state and union territories? Ladakh, Jammu and Kashmir, Lakshadweep, Nagaland, मेघालय, अरुणाचल प्रदेश, मणिपुर, and Punjab. In Punjab, Hindus are in minorities, Sikhs are in majority. Okay, so these are the 9 state or union territory where Hindus are in minority. So the petition which was filed in the Supreme Court in this case was about that since minorities are to be declared state specific, so these states should be instructed to declare the Hindus as minority in the respective state. Okay, so Supreme Court said that it is not required. Even though a state government has not declared someone as a minority, all those who are in minority in those particular states, they will enjoy the protection that has been given to minorities in Article 29 and 30. I hope you remember what are the protections given to minorities in Article 29 and 30. Okay, the moral of this story is these two things, that even though a particular state has not declared, so it is not necessary to be declared. If a minority right is taken away, then the person can approach the Supreme Court for violation of his rights, or person or even institution. Next, we shall see what are the constitutional provisions. This is a question that has been very often asked. What are the constitutional provisions related to minorities? Not related to minorities, but related to scheduled caste. This has already been asked. So there are very high chances that next turn could be for minorities. So see, you can always talk about the right to equality and right to freedom of religion. Right to equality says that there cannot be any discrimination on the basis of religion. So in a way, it is protecting minorities. Right to freedom of religion specifically says that there would be freedom to practice, profess and propagate your own religion. So this is also, these are also the protection that implicitly gives into minorities. But there are a few articles which gives explicit protection to minorities. Okay, like Article 29 says that no one shall be denied admission to any government school on the basis of religion. Just because a particular person belongs to any particular religion, he shall not be denied admission to any educational institutions. Okay. Article 30 gives right to minority education institutions. Okay. That you can have a right to establish and run the minority educational institution. In fact, it is also said that minority educational institutions enjoys right to property, because the article says that if their property is taken away by the government, acquired by the government will pay due compensation. Okay, so it is said that right to property, although it has been taken away for normal citizens, it is still a fundamental right for minority education institutions. Okay. Then even under Article 15 and 16, not 16, Article 15 says that in terms of education, affirmative action can be taken. Article 15, 5 and 6. 6 is for economically weaker section, 5 is for OBCs. But these articles give exemptions to minority education institutions. So in case of minority education institutions, the reservation does not apply. Okay. Even Right to Education Act does not apply to minority education institutions. This is also something which was in news a few days ago. Next is, there is also Article 347. This Article 347 says that uh, President can recognize, you may write it down, President can recognize a language spoken by a section in a state. So, if a particular section of population in a state is using a particular language, the president can recognize that language to be used for various purposes. Okay, so now president will say that for what all purposes, like it may be used for the education purposes, may be used for the communication purposes, may be used for signboard, or whatever is the discretion of the president will issue an order or notification that this language. So effectively you have to remember, the president can recognize a language spoken by a section, language spoken by a section of population in a state. For what purposes is the discretion of the president. So central government effectively can issue order to the state government that, see, you have to use this language as well for these purposes to protect the interest of the minorities. Okay. Next is Article 350B. We have just covered it. What was it? 350B was a special officer for protection of linguistic minorities. Okay. What is Article 350A? So, Article 350A says that the facilities would be provided for instruction in mother language, okay, up to primary level. So, a research has also confirmed that if a kid is taught in mother tongue till primary level, the learning is faster. So, because initially at the very beginning of one's life, the kid learns not only by listening, rather he simply does mimicking. Whatever things that you say, he will mimic that. He will mimic that with his whatever complete or incomplete voice capabilities that he develops. Okay, that's why it is also said that if a person does not remain in a group, that person may not learn various languages, whereas those kids who often remain with the various animals, birds, etc., they also are able to bring out the voices of those animals, etc. Okay, so that's why it is very easy if the language in which everyone around is talking is also the language to be used in the primary schools. The learning outcome is faster. The constitution does not talk about the same in case higher education or secondary education, because at that point of time, like in higher education, most of our higher education websites, see the vernacular that we use to study, that vernacular is the word that we very often use in say history. In modern history, in British context, we have been using this word vernacular. Vernacular reflects to Indian languages. Okay, when here in this context, mother tongue is the word being used. Mother tongue can vary from place to place. For example, or in this context especially, just take the example of, say, a person who is Hindi speaking person and he is in say Andhra Pradesh. So this constitution says that probably an effort would be made if a community is residing who is speaking Hindi. So the education should be given in Hindi. Suppose a community is there which is speaking Tamil, staying in, say, Andhra Pradesh, then efforts should be made that the primary education should be provided in Tamil. Okay, but when we are using the word vernacular, we are not distinguishing that even if it is being provided in Telugu, it is vernacular education. Even if it is being provided in Hindi, so vernacular was in this context that anything which is native language of India. Okay, so slight difference is there, not much of difference, because in India we have education in either like mother tongue, like whatever is the tongue of the that community in that region, or in English. So that's why more often, mostly, vernacular is the mother tongue. But sometimes it may not be in case of the minority communities staying in a particular state. Is it clear, Manoj? Next, we are going to study about National Commission for Minorities. However, like if we go by the strict definition of vernacular, as such vernacular definition is that the language which is spoken by the people of a region. Okay, so in that context, you can say that probably vernacular is same as the mother tongue. Mother tongue is the language which is spoken by the people. Okay. Next is National Commission for Minorities. See, the same thing I am going to discuss about the challenges and way forward. The same thing is applicable for National Commission for Minorities, same for women, same for protection of child rights. These are all three bodies which are a statutory body. Okay. The challenges are same. The challenges will start in the appointment. In appointment, the appointment is done by President, that is Government of India. Invariably, there is politicization of appointment. These posts are filled by those people who are often political people, who have political inclination. So that's why there is also a problem that experts are not appointed. Those people who have, like for example in child rights, so those people who have worked in that field, those people should be appointed. But it's felt that anyone can have talk about the child rights, even those people who have beaten their children when their kids were small, those people are also appointed for the protection of child right. The next thing is that their role is always recommendatory. So this is true for all commission, whether it is constitutional, non-constitutional. Their expenses are not charged on the consolidated fund of India, so they have financial dependence, not only constraint. We can say that they have dependence on the government. So if someone is having financial dependence on the government, it is definitely leading to the lack of autonomy. You can function with autonomy only if you have your budget covered. If you are dependent on someone for the budget, that person can always pull the string and say that, okay, if you do this, I will cut your budget. You cannot give any recommendation which can put government or which can question government. Then for staffs and also for investigation purpose, suppose they come across anything wrong happen, especially National Commission for Women. A lot of crime against women keeps on happening in our country, unfortunately. So if they have to do any investigation, etc., primary investigation, they can themselves go to the site, etc. But later on, for detailed investigation, for any prosecution, etc., they are dependent on the government only. So ultimately, they will recommend to the same government about any action to be taken. The same action that the same government that initially did not take any action will be asked to take action. Obviously, they are not going to take any action. Then, in most of the policy matters also, the government often takes unilateral decision. Government does not bother to consult, and their uh, like obviously their recommendation is not binding. So sometimes government consults, sometimes government does not consult either. Okay. Next aspect is what's the way forward? Way forward is again in this context only you can give the way forward, that there should be wider jurisdiction for all of them. Like investigations should also come in their ambit, include the power to investigate. They should be allowed the power to offer compensation, even if they feel that yes, something wrong has happened, they cannot give compensation. And their recommendation, there should be some mechanism to make the recommendation enforceable. Okay, like there could be a provision that only parliament can reject the recommendation. The recommendation would definitely come as a bill, then parliament can reject it. Okay, some kind of that kind of provision should be there. Then obviously financial autonomy, you can always recommend that there should be, their expenditure should be charged on consolidated fund of India. You can always talk about mandatory action taken report. This is like from second only. Then in their appointment, there should be transparency. You can here also recommend a committee system involving neutral expert, opposition and government. It should not be only government that should be appointing. The government, some outside experts and opposition. And then you can also talk about giving them constitutional status. Although we have studied that merely giving constitutional status may not make them more effective. However, definitely it will raise their status. So one of the suggestions you can always give for those bodies which are not having constitutional status is that they should be given constitutional status. Is it clear? Any doubt? Like 5 points both sides? And then for all these bodies, whenever they come in news, whenever like when in case of National Commission for Women, you have the various status about national women status that you can talk about, that whether National Commission of Women has been able to successfully address these issues. And then you have to talk about all those things not only in one dimension. One is legislation, another is implementation of legislation, then policy, implementation of policies, crime, 5 dimensions are there, then socio-economic status, political status. From all these perspectives, you can always talk about all these categories. Children also you can talk about, minorities also you can talk about, whether their status is there or not. Okay, so whether these commission have been effective or not, one aspect we will talk about, that the communities they are supposed to safeguard, protect and develop, these communities have not developed, they are not coming to mainstream, and these are the challenges, these are the way forward. There is a comment I am not able to read, if you could zoom it. Yeah. Sir, is there a restriction on appointment of persons such as in minority commission? Members should be minority. In case of women's, only women's should be member. As such, there is no restriction legally. Okay, but by convention, majority of the people, Like in case of protection of child right, there cannot be like children in that commission. So in by convention in minorities, like chairman is always from minority community. In women, chairman is from the women community. Majority of the people are like majority of uh, um, members of the National Commission of Women are women. Majority of the members in National Commission for minorities are minorities. But again, this is legally not binding that only they can be member, but it makes sense. Okay, that minorities should have majority in those commissions. But see, especially, I mean, since the matter is here, like in case of National Commission for Women, women issues are as such not women issues per se, they are gender issues. They are the issues where the role of both the genders are involved. You cannot give prominence to women without involving men in those causes. See, if domestic violence cannot be stopped merely by talking to women, merely by talking from the woman's perspective, you got to understand the plight of men also. Why is their approach so wrong that they are engaging in domestic violence? Maybe the counseling has to be done to the men, and the counseling has to be done to the men. There has to be some men member also in this commission to give perspective on the men's thinking. Okay, so a discussion would be enriched only if we have members from the members who are not belonging to these communities. Okay, but yes, majority of the members of these commissions are definitely from those communities. Okay, next we are going to discuss National Human Rights Commission. This is something like in prelims two times probably the questions have been asked about National Human Rights Commission. Mains also question has already been asked, but this is something which is an evergreen body. It can attract further questions. Okay, so like the questions, we are not going to discuss about the aspect which are there about appointment and security of tenure removal, etc., because those are the things which are more related to prelims. But still, if you just give me answer, like the chairman of NHRC could be a chief justice of retired chief justice of India or judge of Supreme Court. To appoint the members, there is a committee of 6 members, the largest such appointment committee members that is there. It is headed by Prime Minister. Then there is a Speaker of Lok Sabha, leader of opposition in Lok Sabha. Then there is Deputy Chairman Rajya Sabha. Then there is leader of opposition in Rajya Sabha. And then there is Home Minister. This is the 6-member body that appoints members to the National Human Rights Commission. Okay. We shall discuss it again. The question could be about their effectiveness and not effectiveness and what are the challenges. So, we will discuss from two perspectives, where they have been effective and where they have not been effective. Okay. First is that obviously their contribution has been in investigation. Wherever the matters of human right violation happens, they are often engaged in investigation. For example, as per their official data, approximately 1 lakh complaints of human right violation is received every year. So they are acting as a major grievance redressal mechanism. 1 lakh complaints are being dealt by them every year. Okay. Next, you can also give some examples. Like in case of violence against Northeast people in Delhi, the National Human Rights Commission took suo motu cognizance. In case of Hathras gang rape case also, it investigated the matter. So there has been various cases where National Human Rights Commission has swung into action and has taken prompt action. Then it also makes recommendation to the government about various policy measures. Like in case of prison reforms, they have played a very important role. Like Human Rights Commission members and even the volunteers who are engaged by NHRC, they very frequently visit the jails or even a reform center or juvenile homes, and like their recommendations are often implemented as well. Okay, so these are the areas where they have really done commendable work. And then they also spread awareness. You can write this example like a stand up for human rights. This was the hashtag which was made popular by NHRC. Then say no to rape campaign. These are the campaign that has been run by NHRC. So these are the few examples, like in case your preparation time, if something wrong happens and NHRC swung into action, you should compile those examples over here. The latest data, if you give latest example, it would be better. Next, we have to see that where they have not been successful. So see, any organization does not become successful on two places. First, if the action is happening far from Delhi. In Delhi, very active. Like if pollution in Delhi is very much talked about. Supreme Court takes suo motu action, a lot many action is taken. But the same pollution, if it is happening in, say, mining activities are happening in the tribal region, in the Jharkhand, in Chhattisgarh, no one is bothered about. Okay. So the first thing is if it is in far from Delhi. And second is if an influential person is involved. If the or the third thing would be if crime is happening against a helpless person. So first crime is happening or whatever action is happening at a faraway place, then these bodies would not be very much active. Second is the victim is someone who is very poor, he is from the backward area, or he himself is a say backward person, then the chances of these bodies swinging into action is very less. Until unless like the crime is so heinous, somehow it has got the media attention, something like that. Okay, like yesterday I was seeing in the on Twitter, one news was circulating that in Chhattisgarh, uh, there was a person who was shot. He has a bullet wound, and then he was taken to the hospital, and there he died. So obviously his body was handed over to the family, but then his wife, who was eventually pregnant also, she was made to clean the blood stain on the bed on which her husband was kept. So imagine the thought process of the people over there. There is a lady whose husband has died, and you are making her clear the blood stain in the hospital, in the public hospital. So this is the lack of what you say empathy or compassion. This is the example that you can use in your ethics paper as well. So if it is happening with poor people, then also these bodies, this is also a violation of human right. And then if the crime has been committed, like perpetrator was someone who is very, not only crime, any action, the perpetrator is very influential, then also these bodies would be mute spectator only, especially if the influential person is close to the government. Whoever is in the power, in that case they become mute spectator. Okay, let's see few examples I have brought, but this is a common tendency that you can write. Failure against mighty and powerful, and especially with respect to these bodies, whether we talk about Human Rights Commission, even like National Commission for Women, in case of security forces, their mandate do not run to the security forces. Action taken by security forces, I mean, most of the time the human right violations are done by security forces, and their their accountability mechanism is very weak, and it is even more toothless when it comes to Armed Forces Special Power Act, because in these cases at least they can ask questions. Okay, although their effectiveness is very less, but here they cannot even ask questions. They cannot do anything. Yes, definitely, Manoj, you can use the local news example. It should be true. It should look true. Okay, do not, I would not say that do not fudge the example. Do not create example of your own in a in the exam, because the way you write your fictitious example, examiner is prudent enough that he will be able to decipher what is fictitious and what is real. You may not understand the difference, but as soon as I read an example, like it has happened n number of times when I have been evaluating the copies, and I ask the student whether this example is real or you have created of your own. And almost always I have been right that the person has said that, sir, actually this is, I mean, I just wrote it. So examiner is always going to decipher the difference. So do not try to create an example, but yes, you can use the local examples. But if you are genuine enough, you can create a repository of examples which are famous, which comes into national news. Okay. Next is like in high profile cases, they are very less effective. Like in case of say Gujarat riots, limited influence on policy decision. Like police reforms, this is something which is yet to happen. We don't know when will it happen. Even after Supreme Court intervention, it is not happening. So what can NHRC do? Next is they have certain structural limitation. Structural limitation as such, like I have divided their limitation into two parts: structural limitation and then functional limitation. However, it is very difficult to distinguish between the two. A structural, I have put those things which are there in say in terms of law, which are there in terms of the structure, which you can see that yes, this is not right, that's why it's wrong. And functional is, although you cannot see it, but practically the way things are functioning, it is not giving adequate result. So that is functional limitation. So structure is that they are recommendatory body, their recommendations are not binding in the government, so it is often ignored. Although with respect to NHRC, there is one more right thing, like government has to report back to NHRC about the action taken on its recommendation. That's why there are high chances that in case of NHRC, the government would take action. Because see, the correspondence between government and NHRC is often, I mean, until unless it is subject to, what do you say, uh, if it is intentionally, it is sensitive matter or it has been like declared an secret document, these correspondence are subject to RTI. And since government has to take the action taken report, so whatever action taken report the government communicate to the same body, it is also accessible under RTI. So that's why there are very less chances the government will ignore. There are high level of acceptance, but again, challenges, we can say that they are recommendatory. Sometimes they are ignored, or like in recent time the frequency has increased. Then they have limited investigative power. They relies on reports from the state government. They will again ask the state government only to produce the report. They do not have their own investigative, what to say, staff either. Like they are very a staff crunch is always there. Again, they will ask the government agencies, the government police or the investigative agencies to do the investigation. They cannot themselves punish the violators. Ultimately, after the investigation, they will ask again the state government to prosecute the matter, and the government will decide the prosecution and will go to the court or not. Okay, they can't punish the violators, and they can't even ensure the prosecution. The government will decide whether to prosecute or not even after the investigation. But yes, their uh, what you say, their authority extends to giving order for investigation. That is something that they can do. Then they have limited jurisdiction that can't investigate more than 1 year old cases. If a case is, this is something I don't know why it has been like a lot many people questions it, that why you have this limitation that NHRC cannot investigate a matter which is more than 1 year old. Probably the logic is that like if such an old matter is being opened by NHRC, it can lead to misuse of NHRC as an institution. But well, the courts can take up, the police can do the investigation. So why can't NHRC? Okay. Next is some practical limitation. Like there is no separate cadre of investigative officer, lack of cooperation from a state government and central government. Like this is something which is not there written in the book. But yes, obviously, whenever NHRC is investigating a matter, it will go either against the central government or against the state government. So these government will definitely do not like an active NHRC. So they will do everything possible on earth to not allow NHRC to be active. Okay. And then funding and staff resource concern. This is common for all agencies everywhere. Funding, awareness, these are the common point. Lack of awareness vis-a-vis human rights. People itself are not aware. Like even I can give you my own example. Uh, there was one person in my college. Uh, I, I mean, after coming to UPSC preparation, I understand how good he was. But when I was in college, a lot of my friends used to make fun of that person. Why? Because he used to talk about the brutalities of armed forces in various regions, especially border related regions, etc. He used to post those videos, etc. at that point of time when we were in the college. And most of my friends, including me, I'm ashamed of that fact that at that point of time I did not understand that there is something called human right which was being violated. We used to say that what kind of nonsense is posting. So like the undergraduates in IITs are not aware of these things. I can very safely assume that probably same is the level of understanding among majority of youths of our country. This needs to be improved. Then only when people are aware, when there is a pressure from the bottom, the government authorities will also be more, what you say, cautious. Like another thing which is like definitely human rights violation, a lot many of you might still be thinking, and this instant justice. The trend has come, there is going to be encounter killing or bulldozer justice. These are not a good thing. These are, what to say, excess by government agencies. These are human right violations. And in the interview or in your mains answer, you do not have to ever justify these things. A lot many people do give the argument that see if you go to the courts etc., then what will happen, the cases will take on time, adjournment after adjournment, tariq pe tariq will happen, and that person will come out of the prison one day and again will threaten, kill or maim the same person who had complained against him. Well, the solution of this is not in doing the encounter killing. Rather, the solution lies in improving the judicial system, improving the criminal justice system. Encounter killing is going to make the criminal justice system further more arrogant, unaccountable, and further lack of responsiveness would be there. Okay. Next is, what is your suggestions? You can easily think about the suggestion I have given. So there is a suggestions. First is that apart from these things that we can discuss about NHRC, should also give a suggestions is about implementation of police reform. See, human right matters are invariably linked to the policing, and until or unless we have robust policing system which is sensitive to the human rights issues, that point of time we cannot have human right protection regime in our country. Okay, and one of the investigate suggestion was there in the police reform is there should be separate cadre of investigating and prosecuting officers. Sorry, this is about investigating and prosecuting officers with NHRC. Like, NHRC should have a dedicated cadre of investigating and prosecuting officers, that it should be able to investigate and prosecute the matter. Okay, and it should be empowered to award the relief to the affected parties. Its recommendations should be binding on the executive, and HR violation by armed forces should be brought under jurisdiction. As of now, like the protection which is given, this is another thing, that protection under APSPA should be withdrawn in case of human right violation. So these are the same thing that we have to tell, same similar line, that they should be powered, their recommendations should be binding. Just a specific thing is about armed forces. Human right violations are invariably linked to the armed forces, police forces, security forces. Okay. Now we shall move towards the next topic, that is regulatory bodies. If you have any doubt, you may ask. What is regulatory bodies? Can you give me some explanation or any definition? What do you understand by regulatory body? Which are the bodies, or what could be the feature of a body that we will call it as regulatory body? So regulators are those regulatory bodies, or regulators is one and the same. Regulators are those agencies which are involved in setting standards in a particular field. They will set that how various stakeholders in a field should act or not act. The best example of the regulator is RBI. The best I'm saying is because you read about something, you read about RBI every day in the news. That's why I'm saying this is the best example of a regulatory body. It doesn't mean that others are not regulators enough. So RBI set standards for whole of the banking sector, that what criteria should meet for getting the banking licenses. So not only it will set a standard, it will also issue licenses, etc. So regulators are often involved in issuing certification, issuing standards, and well, like those who will meet these standard, it will issue certificate that you are meeting these standards. At the same time, if you will not meet those standards, then it should have some authority, some power to enforce those standards as well. So the organization which is involved in all these activities are often called as regulators. Okay, let's see what could be the definition of a regulatory bodies. These are independent governmental bodies. One important aspect of them is they are independent governmental bodies. So often they are directly not part of the ministries or department. They are often created by an act of parliament. Okay, they are created by an act of parliament. They are not, see, they actually work under ministry, but this doesn't mean that they are part of the ministry or department. They are autonomous, they are independent. Okay, governmental bodies established by the government in order to set standards in a specific field of activity. So regulator would be dealing with a particular field. For example, RBI is dealing with banking sector, IRDAI is dealing with insurance sector, SEBI is dealing with, what do you say, securities, etc., security market or operations, and then to enforce those standards. So these are the important factors. First is they would be independent. These are all government bodies. Second would be they will set standards. They would work in a particular field of activity, and they would also have the power to enforce those standards. So effectively, what all functions are they going to do? They are going to do these functions. They will issue the regulations and guidelines. Like for banks, the RBI will say that this is going to be the repo rate, this is going to be the reverse repo rate, and all those things. They will also review these guidelines, etc. They will do the assessment, regular assessment of not only these guidelines, regular assessment of the performance of the sector. For example, RBI will always bring about a report on, say, what is the cash deposit ratio, what is the level of NPA. So these are the assessment and review that RBI regularly does. Similarly, all other regulator also do the same thing. Then it issues licenses. Then RBI issues the banking license. And then since they have to ensure that the standards that they have prescribed are implemented, they have the power to do the inspection. RBI does the inspection of all the banks. It goes to like even this is something that is done by the NABARD also. NABARD also inspects. We used to go to the branches of the banks and used to look at the books, etc., that what is going to be, whether they are following all the norms or not. Like there are norms, who to be given loan, how much loan can be given, what could be the maximum amount, or like if this much is the loan to be given, who should be the authority that should be sanctioning the loan. So whether all these parameters are being met or not. Okay, how much cash is being maintained, whether the physical cash actually, this is another thing that happens once, not me, but few of my colleagues have gone to a bank for the investigation, and routinely, like every bank has a locker in which they keep some cash. So routinely the cash is definitely going to be matched. Like the cash that is there in your system will say that currently 10 lakh rupees are there in cash in the vault. We call, in the bank's language, we call it vault. That in the vault of the bank, of the branch, 5 lakh cash is there or 10 lakh cash is there. So this would actually match with the actual physical cash which is there. So usually it matches. Never will it happen that it is not matching. Not matching is means that some money has been taken away by the person. So this is a very routine thing, but still, out of curiosity, those people say that please show us the vault. We want to count it. Okay. So when they open the vault, they found that in place of the pictures of Gandhiji, the Bandar Chhap notes have been kept by the cashier. So actually, whether the manager did it or cashier did it, no one knows. Okay, obviously both are being prosecuted, both are claiming innocence, but definitely some of them must have done it, but practical this is also happening. So when you actually go on paper, everything is looking right, that yes, minimum 5 lakh rupees should be there. I mean, there are certain norms that minimum this much rupees should be there in the vault, that much money has been there in the vault. Everything is on paper right, but practically in place of the real Gandhiji notes, there are Bandar Chhap notes which are placed over there. Okay. So in inspection happens, like sometimes off-site inspection also happens, sometimes on-site inspection also happens. On-site inspection like actually physically verifying certain things. Off-site is like looking into the books of the accounts etc. that is to be submitted to, reports etc. are submitted every month to the RBI or whichever is the regulator. And then obviously if something wrong is found, then corrective action has to be taken. Like RBI very often issue orders. RBI has recently also issued order that some NBFCs will stop functioning. RBI had last year or last to last year stopped HDFC from issuing new credit card. So it often takes something called prompt corrective action. And then enforcement of these action and other regulations etc. is the functions of RBI. No, all the regulators. Okay, so these are the common functions. You can take any regulator, any example, or multiple regulator, multiple examples to write the functions. They will issue guidelines, they will do the review and assessment of their sector, they will issue licenses, do the inspection, take corrective action, enforce the corrective action and their regulations. Okay. Next is that there are certain issues with the regulatory bodies. First is that in these regulatory bodies, often some non-experts are placed. Again, the problem with the appointment, the people who are manning these regulatory bodies. For example, like this is may not be a very good example, but say NABARD is a organization involved in what you say agriculture and rural development. It's as such not involved in commercial banking. This is not something which is done by NABARD. NABARD is a development financial institution, not a commercial bank. So if certain people who are like who have been working in the commercial banks, they are placed at the head of the NABARD, or like say RBI. RBI is an institution who is dealing with the monetary policy. If a retired IS officer is made a governor of the RBI or deputy governor of RBI, on the face of it, it seems that they are expert. They have worked in commercial bank, they have worked in say finance ministry, but say finance ministry is dealing with fiscal policy, not monetary policy. IS officer are anyway generalist in nature. RBI is doing a different work, so there has to be a exact similarity because these regulators are working in a particular sector. And that's why, see, one more thing before we move further, one more thing that you should understand, why we need regulators and why has there been a proliferation of regulators in recent time. Have you ever thought of it? Why can't these functions be done by government itself? Like, why government has to make a government bodies to do these things? Why can't government do itself? See, most of the regulators like RBI was there since independence, but most of the regulators which are there have come into being post LPG reforms. After LPG reforms, what happened that now government allowed private sector in almost all fields. Private sector is allowed in all fields. Government also said that those of our organizations, those of our bodies which are competing with the private sector, they would work as PSUs. Okay, so a few government departments were also converted into public sector undertaking. This is how BSNL, MTNL, they came into being. Earlier it was like Department of Telecommunication was dealing with all these things, telecom, etc. Okay, so now there is government company, there are private companies, both are competing with each other and working in our economy. Now earlier, first thing, when only government companies were functioning, they were functioning under the overall authority of the ministry. Minister was in charge of them. As such, there was no need of any independent regulator. But now that multiple players are there has to be a regulator to regulate them. There has to be an umpire. An umpire has to be independent. Why? Because these private players are competing with the government companies. So if there is, it is like this company is under ministry. There is a minister in charge of these companies. If the same ministry is also doing the regulation, this regulation would be often considered biased. There will have bias. So that's why regulators were made independent of government so that they could regulate the government in an unbiased manner. They could regulate the government PSUs in an unbiased manner. Okay. Now see, if government is appointing its favorite, in that case, our government is interfering in the functioning of the regulators, the same principle is violated. These regulators have to act as a neutral umpire between government bodies, government companies and private companies. They would fail to do so if there is a government interference. And government interference is not mostly about giving benefit to the government companies. It is also about political, it is also involves political interference for political gains. Okay, here you can give the example, IAS officer becoming RBI chairman, RBI governor. Their recommendations are often not implemented, like SEBI recommendation about corporate governance and investor protection. SEBI recommendation about corporate governance and investor protection. Investor protection. Then these regulators often have overlapping jurisdiction. There was this classic case of ULIPs. Have you heard of it? ULIPs, unit linked insurance product. So like in case you have taken the insurance from Bajaj Alliance, uh, this is something that happened during 2008 boom. So 2006, 7, 8 was the period when share market was going very high, and it was breaking records after records. So at that point of time, this Bajaj Allianz company came with these ULIPs, unit linked insurance products. So as such, what happens that the premium that you you invest certain money. A part of it goes for insurance premium. The other part goes towards is invested in the security market, and the money that you receive is linked to the unit that you have bought. So in as such, in security market, you buy mutual fund. So it is as such investment in a mutual fund, and as your mutual fund performs, so is your investment. So it is having like both the things. One unit was having insurance product, it was providing you life insurance, and so suppose you have paid a premium of 10,000. Out of 10,000 rupees, maybe 1,000 rupee will go towards insurance premium. Okay, rest 9,000 is invested in a mutual fund. You will get return based on how your mutual fund performs. Unlike LIC insurance, where you get a assured return. Here, your return is linked to the performance of your mutual fund. Initially, it so happened that in 2006, 7, the share market was performing very well. So, like a lot many people saw that after 3 years, their money was doubled in 3 years time. A lot many people invested. One of my cousin also invested, but he invested in 2008 when share market was at its peak, and then it crashed. Later on, 6 years later, in 2014, he withdrew his money. In 2008, he has invested around say 30,000 or so. In 2014, also he withdrew the same 30,000 rupees. So this is how a lot of gullible investors lost their money in the 2008 financial crisis. They were not even aware that were taking a risk. They were investing in mutual fund. The companies which were selling them was selling them in the name of insurance product, that you are getting insurance and then your money would be doubled, unlike LIC where you get a paltry interest income. Okay. Now, when the matter came to the picture that which was the regulator that failed, like IRDAI, Insurance Regulatory Development Authority of India, which regulate the insurance sector, this said that yes, these products would be now from now onwards regulated by me because these are insurance products. But at the same time, they were having the element of mutual funds, so they were supposed to be regulated by SEBI also. So there was a turf war between these two regulators, and these companies took advantage of this turf war. Okay, so companies often come across these products which is not included in the ambit of any one regulator. They design the product in such a way that they could bypass the regulatory oversight. And then who will watch the regulators? Who will regulate the regulators? There is no efficient review mechanism to review the functioning of these regulators. Let's see how regulatory bodies are different from statutory bodies. Both are established by act, only difference in function. Yes, yes, yes. See, like by act of parliament, a lot of bodies are there. So in that context, regulatory bodies are also statutory body. Okay, so statutory body is a wider umbrella. The mere definition of a statutory body is that in case it is established by an act of parliament, a part of these statutory bodies, if this is the whole set of statutory body, a part of it might be involved in regulatory function. So these would be known as regulatory bodies. Okay. Next is what is the way forward? that we will talk about this regulatory body. Way forward is again, the problem was that they were supposed to be independent of the government. There should be lack of government interference, but the same is not happening. In fact, from the same point, again, appointment is done by the government. Government appoints its favorites. Even they do not have the security of tenure. The members appointed in these bodies, they do not often enjoy the legislative safeguard is not there for their security of tenure. There is no security of tenure to them, although they are appointed for a 3 years time, but often government removes them before time if they do not follow the instructions of the government. Like RBI governor has to resign, Urjit Patel has to resign. Okay, so appointment and removal process should give immunity from government interference. Regulators are not, this is again, various articles are written, regulators are not the extended arm of the government. Regulators are there because they need to be independent of government, because they are supposed to be regulating the government PSUs as well as the private companies. So they must be allowed to flourish in their independent way. And if at all government has to interfere, government should interfere through legislative means. Government has parliament. Through parliament, it can make a law which would be applicable on government companies as well as private companies. Okay. And then these regulators do not have the financial autonomy either. Here also we can give the same suggestions. So see, bodies could be different, suggestions are all the same, problem is all the same. Okay, one or two points are different, which are distinct, which are unique to a particular theme. Those 2 points are very important. Those 2 points must be there. For example, like overlapping jurisdiction, that is a key thing about the regulatory bodies. That must be there. Rest of the thing is, same, insulating them from political pressure and all those things, like in appointment, in their working, in their financial matters, in their removal. Like how will you insulate? You will insulate in all these things. How we will do? We have already studied with respect to say the earlier constitutional body, whatever suggestion that we have studied, the same is applicable here. Do not give suggestions about, until unless it is specifically asked, do not say that they should be given constitutional status. Do not give this. Why? Because see, these regulators are working in a field which is very dynamic in nature. Okay, they are dealing with matters which require prompt action. That's why we have regulator to specifically look into those issues which will change very dynamically, and regulations should also change accordingly. So if a constitutional status is given, probably their power, etc., may not be changed so prompt. It would be difficult to change, okay, their power functions, etc., which may be required with the changing nature of economy, with changing technology, with the coming of globalization. Okay, that's why it is better, more suited that these regulators are part of, are made through an act of parliament. So this is not an acceptable suggestion that they should be given constitutional status. They should remain a statutory body, but the statute itself should give them more autonomy. Autonomy should be there in functioning. There should not be government interference. Is it clear? Then there are other suggestions also. There should be regular self-evaluation. Once you give autonomy, uh, who will then tame these regulators? Who will guard the guardian? Okay, so there should be a mechanism of self-evaluation, and obviously self-evaluation may not always happen. Then there should be review by parliamentary standing committee. So there should be a parliamentary standing committee to review the functioning of various regulators, that should regularly review the functioning of these regulators, and since they are made by an act of parliament, accordingly parliament can take action whether these regulators are functioning properly or not. Then they should be subject to the performance audit by CAG. Okay, so CAG is doing performance audit. CAG does two kind of audit. We have studied legal audit and propriety audit. Propriety audit is also known as performance audit, whether it tests the wisdom of decision making. So whether regulators have been acting in correct wisdom or not, CAG can give its comment. CAG should act as an advisor in this role, advisor capacity. It should not act as a fault finding body. Okay. And then we should have a regular regulatory impact assessment. Like we have environmental impact assessment, we should also have regulatory impact assessment. Second ARC has also given a suggestion that, this is another suggestion by second ARC, that there should be a pre-agreed parameters. There should be pre-agreed parameters for performance of the regulator, and annual report that these regulators submit, the annual reports must mention the outcome on these pre-agreed parameters. Outcome on these pre-agreed performance metrics, you can also write. For example, like government and RBI has entered into agreement that inflation targeting is going to be the agenda of monetary policy. Okay, the RBI's priority focus would be to keep inflation around at 4% plus minus 2%. Okay, so now there is a pre-agreed parameter. If RBI fails to do so, it will explain its regional etc. rationale. So similarly, we can have like with respect to NPA also, that NPA would not be going more than 4%. Okay, with respect to various other things like forex reserve, you have to maintain at so and so level. The rupee exchange rate would be maintained at so and so level, or whatever be the parameters on which you can agree that these are going to be the parameters within which you have to show your performance, and the annual report should mention about those performances, what have they achieved. Okay. Any doubt on any of these suggestions? Now, if the question is on RBI, then also you can give the same. Question is about any other regulator, then also you can give the same suggestions. Only in performance, the example will differ, the suggestion etc. will remain the same. The next and the last topic for the day is consumer protection in India. Okay. So, who is a consumer? In economy, you must have studied this, consumer goods. Do you remember it? Should we have a quick revision of economic concepts? So see, there is a category of goods. First distinction is between intermediate goods and final goods. There are certain goods which undergo change. Okay, these are intermediate goods. Next we have final goods which does not undergo any change. In this final goods, there are certain goods which are used for capital purposes, which are used for say investment purposes, which changes other intermediate good into final goods. These are used for providing some other goods and services. Okay, and then we have consumer goods. Okay, here the in terms of consumer protection in India, every end user is considered as consumer. Whoever is using a good or services is considered as who purchase goods and services. Yes, you are right, Manoj. So every end user is being considered the consumer. And why I am teaching you consumer protection is because obviously the Consumer Protection Act amendment has come a long time ago, but it was in the news because the matter has gone to the Supreme Court, where Supreme Court asked, and first there was a debate, Supreme Court asked the lawyers why they should not come under consumer protection. The matter is simple, that see, lawyers are also providing services. So in case they give faulty services, because of that their client lose a case, there is obviously a lot of monetary loss, there is psychological loss, there could be like variety of different kind of loss. A person can go to in prison, go to jail, remain in jail for years because of the fault of his lawyer. So shouldn't they come under Consumer Protection Act? The matter was dealt in the Supreme Court, and like the courts deal with matter in an adversarial proceeding. In adversarial proceeding, what happens that every time there is one lawyer which argues in favor, there is another lawyer which argues from other side. The court will listen from both the side and act as an independent arbitrator, independent judge. This is called adversarial proceeding. Like two adversaries are created, and based on the argument of two adversaries, the court gives its judgment. Okay. Now, in this case, when the matter went to the Supreme Court, then why not advocates should be covered under consumer protection, especially because doctors are already covered under consumer protection. So doctors are also a professional. So lawyers are also a professional. Other professionals are also which are covered. So they should also be covered. So in this matter, there was no advocate that represented against it. In Supreme Court, like court only dealt with, there were advocates which said that yes, no, the lawyers should not be covered under Consumer Protection Act. There was no advocate which represented this aspect that they should be covered as well. Not a single advocate came against him. How can you go against your own community? Okay, so ultimately the Supreme Court also gave the judgment that no, advocates are like, they are pristine people, they are doing something different, so they should not be covered under consumer protection. Although the logics given, even I am not convinced with the logic given. I will tell you what are the logics that has been given by the court. But first of all, you can take down the definition of consumer. You have said, Manoj, that they should not be covered. Why not? What is so special about advocates as compared to other professionals that they should not be covered under Consumer Protection Act? They are providing us services, they are being paid by us for those services. The quality should be there. I am not saying that if they lose, see, their services does not guarantee that they will win the case. But the quality of services, the negligence on their part, so like when doctor also does the operation, you always write that I am allowing, I understand that there is a risk and the patient can die and all those things. You give the undertaking, you sign it before you undergo the operation. Still, if there is any negligence on part of the doctor, like he did not give you the dose of antibiotic, he is doing operation, he must be aware that there must be given antibiotic. So if he did not give the antibiotic, that is a negligence. If he, like doctors leave certain items inside the body. There has been such cases as well. This is negligence. This is covered under Consumer Protection Act. But even after all the due diligence, the patient may not recover. There is no guarantee. There are things which are beyond the capabilities of doctor. That is not covered under consumer protection. If doctor has done everything right, which is supposed to be done. Okay. Now, definition of consumer as per Consumer Protection Act 1986 is that a person who buys goods or avails services for a consideration which has been paid or promised, or partly paid and partly promised, or under any scheme of deferred payments. The important thing is there should be a consideration. Suppose someone is giving you a free advice. In that case, you cannot claim Consumer Protection Act. Okay, see, this does not mean that suppose like along with Horlicks you are given toothpaste. Some certain items come free, na? That is not being considered free here, because you have taken 120 rupees for that Horlicks. So even if you give certain item for free, it is not considered that that is free. It is free only if you had not taken, you are distributing, suppose someone is distributing food for free. Consumer Protection Act will not apply. Okay. The Consumer Protection Act establishes the Consumer Dispute Redressal Commission, and there is a hierarchy. As such, this is not hierarchy. There is District Consumer Protection Dispute Redressal Commission. This is called a district forum, a state forum, and national commission. Why I am saying that they are not in hierarchy? Because their jurisdiction depends on the amount of compensation involved. If amount of compensation involved is less than 1 crore, the matter will go to District Consumer Redressal Commission. If it involves 1 to 10 crore, it will go to State Commission. If it involves more than 10 crore, then it will go to National Consumer Dispute Redressal Commission. Okay, so as such, not that if you lose the case in district court, you will go to the state court, and if you lose the case in a state, you will go to national. If you lose case in any of these commission, the matter would lie in appeal to high courts. Okay. Now, this Consumer Protection Act 1986 has been amended in 2019, and it gave about various rights of a consumer. Okay, and the rights are very simple. There is nothing extraordinary, but if a question comes, you should talk in terms of these rights. Okay, first is right to be informed. Whatever goods or services that you are consuming, you must be informed of various things, like what are the items you are consuming. That's why on any food product you see what are the different nutrients that you will get, what are the ingredients that are used, whether it is veg or non-veg, whether it contains egg or not. All these information, these are covered under right to be informed. One cannot sell you any product without informing you of various ingredients. Okay. Next is there has to be a right to be heard. Right to be heard means in case something has happened with you, there should be a grievance redressal mechanism as well. So that's the most of the food product or any product you see now, they are mentioning that in case you have any grievance, you can mail at this number, you can send your complaint at this address, or you can call at this number. Okay. Then there is right to consumer education, because even if all the information are there, until unless I am learned, I cannot use that information. Okay, so consumer has a right to education as well. Right to safety has also been provided to the consumer. If a product is there, product has to be safe for consumption, then only you should use it. It cannot be that you are saying that it is unsafe and you are giving that product. If the product is not safe for consumption, it should not be delivered to the consumer. Okay. And like even if it is unsafe, the protection and all those things should be provided. Then it should have the right to choose. This effectively ensures that there should be competition. There should not be monopoly in the market. Consumers should have choices. It should not be that something is available at only one place. Okay, so if someone is doing intentional, like see, sometimes it can happen. I only know to deliver something. Obviously, like I only have the patent for particular thing. I can do such things. But if it is being done intentionally through some illegal means, that is violation of consumer rights. And then right to grievance redressal, that is being provided through various like 3 levels of consumer forums. Okay. Apart from that, this Consumer Protection Amendment Act, it also established Central Consumer Protection Authority as a regulatory body. So as such, the consumer forums are a kind of tribunals. Okay, they do not do the regulation function. They do not set the guidelines. They do not do the what you say investigation. Okay, they act as a tribunal. Whereas now, as a regulatory body to issue the guidelines, to enforce those guidelines for a consumer protection sector, this Central Consumer Protection Authority has been established. Okay. Now, it has also introduced regulation, dedicated regulation for e-commerce. It has also said that the jurisdiction of any case would be the jurisdiction of service provisioning, goods or service provisioning. So, if through e-commerce I am able to order a goods or services in my hometown, which is say a district in a state of Bihar, then for that, if something goes wrong with that goods or services, the jurisdiction of that court would lie. Okay. Earlier, the companies used to decide, the producer or the supplier used to decide their jurisdiction. So, at many places you might have seen that for any complaints etc., the jurisdiction would lie to particular high court. So, wherever their headquarter is there, they used to keep jurisdiction over there. Now, it has been made that when you are supplying a particular goods or service in any locality, that consumer will only file complaint over there. He will not come to your jurisdiction to file the complaint. Since you have provided goods and services over there, if any matter is there, that would be dealt there. Okay. So, there was change in jurisdiction of consumer forums. There is a doubt that sir, how a company provide right to choose of product or brand. See, probably there is misunderstanding. All these rights are not provided by companies only. Okay, these are the right enjoyed by consumer. Some are provided by companies, some are provided by the government, some are, for example, last right to redress. Okay, this is different from right to be heard. Right to be heard is to be provided by the company, where company will give you an opportunity to file complaint, etc. But right to redressal is provided by establishing this consumer forum. Okay, so right to choose is again something which has to be there in the market. Okay, there cannot be any collusion in the market. There should not be any monopoly in the market. This is a consumer right. Now, sometimes it can be like the consumer can go to the say, for example, if two companies which are involved, say suppose tomorrow Flipkart and Amazon decides that they are going to merge. Now the people's right to choose is going to be lost. So under this act, the people can go to the consumer forum. Like obviously they can go to Competition Commission of India, they can go to high courts and various other places. But apart from that, under this right, they can also go to the consumer forum and say that our right to choose is being taken away. You cannot allow this merger to happen. Okay. So this is a right to be enjoyed. It can be taken away in various means, and then under Consumer Protection Act also a person can appeal to enforce these rights. I hope I have been clear. Then there was also, like, advertisements is another aspect of consumer protection. Okay, like there are advertisements that get the glow, uh, all those glow within 7 weeks. They will simply say that if you are from, what you say, you will become fair within 7 weeks from unfair. I don't know, it should not be right to say someone is unfair, but that kind of advertisements are there, which are very much misleading in nature. ठीक है? So there was regulation against misleading advertisement also. So there is this thing also which often remains in debate, and maybe in case of say ethics case study, this can be asked to you, that whether those celebrities who are engaged in these advertisements, they should be held accountable or not. Again, it's a dicey case. One set of argument is that definitely a lot many people buy those things, like Boost is the secret of my energy. So like when Sachin Tendulkar is advertising for Boost is the secret of my energy, a lot many people must have bought Boost because they were fan of Sachin Tendulkar, Virat Kohli. Okay, they appreciate that how Sachin could be so fit or Virat Kohli could be so fit. Probably we should also, I mean, my children should also consume Boost, but hardly they were aware that Boost is making their children addictive of sugar, which is definitely not good for their health. So shouldn't Virat Kohli or like all these fitness freak, these people are advocating these cold drinks which are not good for the health, shouldn't they be held accountable if something goes wrong because of these products? If these products are not doing those things, like this fairness cream, shouldn't these celebrities be held accountable? The other side says that, see, celebrities cannot have that much of expertise. They should not go into this investigation whether the product will actually deliver or not. That's not the duty of celebrities. Rather, the duty lies with the government. Like whether the Horlicks will make you taller or sharper or not, the claim whichever is made, like how can any person or celebrity will have the capability to do research to know whether Horlicks will make a person taller, stronger or sharper or not? This, the wherewithal to do all these checks etc. is with the government, is with the regulators. It is their duty, not the duty of the celebrity. Okay, so probably the middle path you can take, that where it is technical in nature, where like on the face of it you cannot know the claims are right or wrong. You cannot held the celebrity accountable. But when it is manifestly arbitrary, when it is completely illogical, even a celebrity, if a celebrity is endorsing those claims also, it is definitely unethical. Okay, so in ethics, this is the stand you can take. In polity, as of now, the government has taken the stand. Probably we cannot hold the celebrities accountable. Okay, who can be held accountable? The companies which are selling these misleading advertisement. The accountability lies with these companies, how they are publishing or circulating this advertisement. And even not only regulation, like penalty has also been proposed. In case of misleading advertisement, the penalty has been proposed. Okay, and there is also a concept of product liability has been introduced in case of defective product. See how this is different. Normally, suppose you have bought a fan and if it is not functioning properly, normally what we expect that if I have bought a fan worth rupees 2000, I should get the 2000 rupees back, right? But since it was not functioning properly, it may happen that it can inflict certain damage to people. Maybe that it was rotating and then all of a sudden some of its parts were thrown with uh, huge velocity and it can damage someone, it can hurt someone. So when we talk about the liability, it also includes the damages that might have occurred to a consumer because of the faulty product provided by you, and in that case the company will not only pay rupees 2000 but might have to pay 2 lakh rupees or 20 lakh rupees. So if you are producing a product that is faulty, whatever be the damages that has occurred because of this product, you would be held accountable. The liability will extend to you. This is the concept of product liability that has been introduced in this Consumer Protection Amendment Act. Next, this is the debate that we had started our class with, or rather the Consumer Protection Act, whether the lawyer should be included or not. I did not see any of your comments. Why shouldn't lawyer? This is the question that was asked by Supreme Court. If doctors can be sued over poor service, why not liars? Sorry, lawyers. Lawyers are often liars. Okay, before moving to this, Supreme Court has said that education is not a commodity. Since education is not a commodity, education providers are also not covered under Consumer Protection Act. Okay. So, Supreme Court has given that lawyers are doing something which is a bit unique. Why? Because first of all, the success does not depend on their efforts only. See, I have just said that there is going to be adversarial proceeding. In case of adversarial proceedings, there is another party also involved. I can give a good argument, but the other party can come up with a very good argument. It doesn't mean that I did not give my best, but still the success may not be there. So since it's an adversarial proceeding, the success also depends on the other party's effort and also depends on the fact of the matter. Suppose if you have actually committed a crime, what can the lawyer do? Okay, so there are facts of the matter also. Lawyers can only give the legal interpretation, can argue the case, it cannot change the facts. So success is not completely dependent on their efforts. And second argument, which is like more logical argument, is that lawyers are, their accountability is not only towards, they are not only responsible towards their client, they are also responsible towards the justice system. Okay, they have a duty towards court also. For example, so this is something here that they are responsible, they are responsible to courts also, to courts and justice system also. For example, if a client ask a lawyer to lie in the court. He is supposed to report it to the judge that I am being asked to do something wrong, something illegal. Okay. So in that case, since his liability is not merely towards the client, his liability is also towards the court and justice system, and whatever the action that he takes, his action also has not only responsible, like his action has wider ramification going beyond his client. He cannot always be understood to act in the interest of client only. Like if he's appealing in the high court, the judgment of the high court is going to be the judgment of, it's a court of record. Okay. So he cannot be serving the particularistic interest of the client always. If he gets a judgment somehow giving a wrong information, wrong precedent, that can set precedent for the future judgments. And then this is not a science. Like the legal field is not science. What does it mean? It means that unlike science where objective standards have been achieved, or rather I can say no objective standards. In science you have objective standards. Like say if you give paracetamol, the fever will come down. But in legal field there is no such objective standards, because of which you cannot hold consumer protection or consumer accountability in the legal field. Okay. Although see, you if you want to give counter argument also, you can give counter argument to all of these arguments. Okay. Because the consumer protection is not for not achieving the result. The consumer protection is always towards the faulty products or services, negligent service delivery, negligent behavior. Okay. Even in science, the objective standards are not 100% objective. It's not that every person who is used the antibiotic will not have infection. Despite using antibiotics, sometimes there could be infection. Okay. So that's why, and it's not that the doctors do not have accountability towards the other client etc. So there can be some other argument can be given. As of now, Supreme Court has given this argument. If a question comes, you have to keep these things in mind. This can be useful in your ethics paper as well. Okay. Next is that in general, what are the issues with consumer protection in our country? See, as such, all the major issues which were there, those have been filled in this amendment that was brought in 2019. So I will just give you a few facts etc. Not many issues which there are still lacking. The issues are there with respect to the way those provisions are being implemented. Okay. First is like there is increasing number of pendency of cases in various consumer protection forums. Okay, like there are total of 5.5 lakh cases are pending. Okay. Second thing is that a lot many consumer protection forums, they do not apply, do not allow online complaint on, do not allow registering of online complaint. Okay. Most of the products that we consume are now a day consuming the products and services in online medium. It would be very handy if online registration of complaints are allowed, and on due dates people can go for argument etc. This is something most of the consumer forums are as of now not allowing. Okay, like even in my district forum, it is not allowed as of now. Okay. Then there is lack of clarity about power and function of Central Consumer Protection Authority. Because see, all the goods and services, they are like provided by something. They could relate to health, education, um, one field or another, and most of those fields are regulated by some regulator or other. Like there is a regulator for fire safety, there are regulator for, I mean, most of the goods and services we have one regulator or another. So in their domain, what is going to be the domain, power and function of Central Consumer Protection Authority? This is not very clear as of now. Okay, and whether, like, what would be its power with respect to investigate and inquire, because we also have the consumer forums, etc., which can issue investigation order, etc. So what would be their authority vis-a-vis consumer forum, especially in the domain of investigation and inquiry, is still not very clear. And the last thing is that we all keep shouting about our rights. Where are our duties? The duties of consumers is often neglected by the consumer themselves. Okay, so that's all that we shall have in today's class. This was the second last class. In the tomorrow's class, we are going to cover the comparison of Indian constitutional scheme with the other constitutional scheme. That is going to be the last class of the polity. But do not go away. From the next Monday, we are starting with economy. So economic classes will start from Monday. I shall be taking the economic classes also again from the mains perspective. So every day from the mains perspective, we shall be discussing economy from Monday. Tomorrow is going to be the last polity class. If you have doubt with respect to any of the previous classes, you must mention in the comment section. See you tomorrow. Have a nice day.